Committee Room 30. Sound.
Start then, yeah. Aaron, thank you. So just to welcome members to the 27th meeting of the Committee for Justice, and we now declare the meeting open, and to advise members that the meeting will be recorded and broadcast throughout Parliament buildings and also online. And again, just there may be people in the public gallery as well, and just to notify you to keep mobile phones on silent, please. So just again to advise all members that there is a proposed oral evidence session by Barnardo's NI and the Association of Social Workers on the Justice Bill, and just to seek your agreement that we can record this session on Hansard. Are members agreed?
Agreed.
Great, thank you. Just to remind you that you are obliged, all members, to declare any financial or other relevant interests. So you can do so now or before an item is raised if it comes to mind. So any declarations of interest? I suppose just for myself that I have an immediate family member that works in the court service. Okay, members, we're going to move on to item 1 then, which is apologies. And so far I've received apologies from the Chair, Joanne Bunting. And again, I'll note any others. We also, so any apologies to be noted? No, okay. We've also got members online, so we've got Gemma, Doug and Stephen. And again, they'll just indicate when they wish to come in as well. We're going to move on then to item 2, which is just the minutes of the last meeting. They're in your pack on pages 5 to 14 for the 23rd of January 2025. So I'm just going to ask members if you're content that these are a true reflection of the proceedings of that meeting. And if so, do you indicate and give approval that I sign those? Members agreed? Okay, thank you. We're moving on then to item 3, matters arising. So just to refer you to pages 16 and 17 of the meeting pack, and advise you that the Committee for Finance has requested that this committee provide their views on the Department's budget position for 2025-26 by the 20th of February for the impending, obviously, budget bill that's going to be tabled. And to help inform, obviously, our position, Department officials will join us in giving evidence on the 6th of February, so next Thursday's meeting. So again, we'll just agree then that they come forward just to provide information on the implication, particularly around the rise in employers' national insurance contributions, and on the Department, including its arm's length bodies and its partners in the community and voluntary sector. The views of the Department's non-departmental public bodies on their allocations have also been requested as well. So it's just to seek your agreement to note the correspondence from the Committee of Finance, unless there's anything else you'd like to raise. No, members are noted. Okay, thank you. We're going to move to item 4 then of the Justice Bill, and this is a recap on the justice provisions from the Research and Information Services briefing. And again, just to advise you that we have the research officer here, Judith Bailey, who's been with us before. Judith, you're very welcome. And I'm just going to invite Judith now to give an overview of the paper. I know that there's a presentation of PowerPoint, so I'm hoping that our members online can see it. And if there's any issues or queries or you want to stop, then just indicate and we'll do that as well. So Judith, over to yourself. Thank you.
Thank you, Chair, for the invite to address the committee on the Justice Bill this afternoon. I previously attended a committee session back in September, just after the bill was introduced to the Assembly, where I gave a general overview of all 4 parts of the legislation as drafted. So today, you'll be pleased to hear I'm only going to focus on Part 4 of the bill, covering the administration of justice in more detail. So that's looking at 9 of the 34 clauses currently contained in the bill. I'll aim to go through each clause to highlight what the current legislative and policy situation is in each area, the impact of the proposed changes, and some areas for potential further consideration by the committee. So hopefully this gives you a useful basis from which to build in the coming weeks as the committee issues its call for evidence and begins to hear from more stakeholders on this part of the bill. So the first 2 clauses of Part 4 of the bill relate to policing. So Clause 22 amends existing legislation to provide the Northern Ireland Policing Board with the express power to delegate matters to board members and staff. This could relate to the delegation of decision making on matters such as pensions forfeiture, ill health retirement and injury on duty. So there's a significant volume of work involved in these areas, and the department considers this provision necessary in practical terms for helping to ensure more timely decision making. This clause also addresses the judgment in the case of McKee and others and the Charity Commission for Northern Ireland. So this was a case in which the Court of Appeal upheld a legal challenge to the delegation of decision-making powers by the Commission to members of staff. And then Clause 23 relates to policing oversight and accountability, with the current legislation requiring the Controller and Auditor General to audit the Policing Board's performance plan and arrangements to ensure continuous improvement in policing. So Clause 23 is intended to repeal this requirement. So the Controller and Auditor General previously recommended the removal of the statutory requirement to audit the Policing Board's performance plan, and this plan is a report which is developed annually in partnership with the PSNI and contains a range of performance measures and indicators structured around overarching outcomes. However, this is not focused solely on financial accountability, which is the main remit of the Northern Ireland Audit Office. So the removal seems to be aimed at reducing duplication. So the committee will be aware that His Majesty's Inspectorate of Constabulary and Fire and Rescue Services, or HMICFRS inspections, already assess the effectiveness and efficiency of policing, and Criminal Justice Inspection Northern Ireland also has a role in this space. So essentially, the legislative change in the bill will mean that the Northern Ireland Audit Office will no longer produce an annual report on continuous improvement arrangements in policing. However, provisions do still remain in the legislation to allow for an examination of the board's compliance if this was ever to be required. So the next three clauses of the bill relate to criminal proceedings. So Clause 24 corrects a drafting error in the law relating to conspiracy to commit offences outside Northern Ireland. So the law currently states that criminal proceedings can only be instituted by or with the consent of the Attorney General for Northern Ireland. And Clause 24, the Justice Bill, will transfer consent to the Advocate General for Northern Ireland, and this would bring Northern Ireland into line with the position in England and Wales where the consent of the Attorney General is required, who is also the Advocate General for Northern Ireland or the Chief Legal Advisor to the UK Government on Northern Ireland law. So, as well, what do we mean by conspiracy to commit offence outside Northern Ireland? Well, a conspiracy offence by its very nature is essentially an agreement to commit a substantive offence at a later time, and the question of a broad approach being taken to jurisdiction in conspiracy offences is an interesting one, as a whole range of technologies can be used to formulate an agreement to commit an offence. So given the international context in which this type of offence may be formulated, this transfer of consent under Clause 24 may be intended to act as a safeguard. So, Clause 25 addresses a legal gap in existing legislation to prevent a charge of murder or manslaughter from being no-billed when linked to an offence of causing or allowing the death of a child or vulnerable adult. So what does the term no-bill mean? Well, a Crown Court judge can order a no-bill in respect of any indictable offence that a person has been charged with if they consider that there isn't sufficient evidence to justify putting the person on trial for it. So this means that the charge for the indictable offence would then be dropped and the person would not have to face trial for it. So the proposed changes in the Justice Bill relate to an existing piece of legislation under which there's an offence of causing or allowing a child or vulnerable adult to die, which was subsequently extended to cover causing or allowing a child or vulnerable adult to suffer serious physical harm. So this existing legislation is intended to address scenarios in which there are maybe two caregivers in a household, but no evidence to suggest that they acted jointly. So really one caregiver caused the harm and the other did not take reasonable steps to prevent it, but there's no evidence to implicate one over the other. And under this offence, the prosecution doesn't have to prove which defendant caused the death or harm and which allowed it. So as you can see from the slides, if a magistrate's court considers there sufficient evidence to charge a defendant with one of these offences, then there will also be deemed to be sufficient evidence to put them on trial for the other more serious offences highlighted. So on the no-bill element, the Crown Court judge can only enter a no-bill in relation to attempted murder, grievous bodily harm or non-fatal strangulation if they also do so in relation to the offence of causing or allowing serious physical harm. So given the evidential difficulties in this type of case, this removes the risk of the more serious charges of attempted murder, grievous bodily harm or non-fatal strangulation being dismissed prematurely before all the evidence is heard. So the gap arises as under the existing legislation there's no equivalent provision to restrict the entry of a no bill in relation to causing or allowing a child or vulnerable adult to die. So this is what Clause 25 is intended to remedy. So I suppose in practical terms, this change seems to be a positive one. In England and Wales, a judge cannot enter a no bill on a charge of murder or manslaughter unless the charge of causing or allowing death is also dismissed. So it's unlikely there'll be many cases where this anomaly in the law will be relevant, but at present, locally, it appears that judicial discretion would be required to refuse a no bill application in such circumstances. And in terms of sentencing, the maximum penalty for the offence of causing or allowing a person's death on indictment is 14 years imprisonment or a fine or both. So in theory, a defendant could receive a lower sentence if an entry of no bill is accepted against the murder or manslaughter charge. So in summary, it's quite technical, but this change will align procedures for offences of causing or allowing a child or vulnerable adult to die with the arrangements currently in place for causing or allowing serious physical harm. So a defendant would therefore face trial both for murder or manslaughter and for causing or allowing a death, allowing all the evidence to be heard in the round before a decision could be taken on whether there's a case to answer. So moving on, Clause 26 of the Justice Bill relates to the examination of a defendant in criminal proceedings through an intermediary. So the proposed changes aim to address a specific gap identified by the Victim and Witness Steering Group in the provision of registered intermediaries for defendants with communication difficulties during appeal proceedings. Legislation currently allows for the examination of defendants through a registered intermediary in magistrates' courts and Crown courts. The amendment will provide in legislation for registered intermediaries where there's an appeal from the magistrates or Crown court to the county court or the Court of Appeal. So registered intermediaries already provide assistance in appeal courts at the discretion of the judiciary. However, the department previously told the Research and Information Service in correspondence that it expects an additional 2 to 3 cases per annum as a result of the provision at a cost of around £300 to £400 per case, which it forecasts will be met within existing budgets. So these changes only relate to the criminal courts, but there was also a consultation in 2022 on the feasibility of extending registered intermediaries to civil and family proceedings. So this is not covered in the Justice Bill, but it might be worth just clarifying the status of this, which was recommended by Sir John Gillen's review of civil and family justice. So Clause 27 relates to the statutory charges register. So what is a statutory charge? Well, as you know, the Legal Services Agency provides legal aid for civil legal services in a range of circumstances. So the sums expended by the agency in paying legal practitioners will create a first charge over any property which is recovered or preserved by that individual as part of legal proceedings. So this is known as a statutory charge. And the Legal Services Agency will therefore expect to be repaid out of property preserved or recovered by the recipient of legal aid. For example, that might include pensions or a house as part of a divorce case potentially. And the agency can decide not to insist on a property being sold and instead opt to defer repayment until it is sold using a charge to secure the interest of the legal aid fund. So it registers the statutory charge on the property to protect its interest, and this will also alert potential purchasers to the existence of the charge. So the Legal Services Agency can't currently register this charge in the statutory charges register, as the legislation which gives the agency the power to impose and enforce their statutory charge is not included within it. So Clause 27 would address this issue and allow for the registration of statutory charges in the statutory charges register. So this was consulted on by the department in 2022, but it might be worth the committee probing further around how this change will practically aid transparency and whether there would be any unintended consequences for conveyancing solicitors just with relevant stakeholders. So Clause 28 relates to legal aid, and this will amend existing legislation to impose restrictions on the taxation of legal aid costs. So first of all, what does the term taxation mean? Well, it's a procedure through which a solicitor or barrister submits their bill in respect of a case to the taxing master, who is an independent judicial office holder, who will assess and determine the amount of legal costs to be paid. Once this process is complete, the taxing master issues a certificate for the costs allowed, which is presented to the Legal Services Agency for payment. The power to enable costs to be taxed can be derived from governing statute or from the order of the court, depending on the type of proceeding. So it's envisaged that Clause 28 of the Justice Bill will support the future introduction of alternative methods of determining the remuneration payable in relevant legal aid cases, so standard fees. This proposed change was previously recommended by the Public Accounts Committee and featured in the Access to Justice review, and the Department most recently conducted a consultation on it in 2022. So there are a few areas for consideration by the committee on this issue which it may be worth exploring with stakeholders. So will restricting the role of the taxing master actually give effect to greater predictability around legal aid payments? And is there the potential for any future impact on access to justice? The Department has indicated it's planning a phased approach to reform of fees with High Court bail applications, Criminal Court of Appeal and judicial review proceedings, which are all currently assessed by the taxing master, initially identified in this mandate. But it may be worth asking what the longer term plan in this area is. And what about family and children order proceedings, which account for a significant proportion of tax legal aid expenditure? And as well, what remit will the taxing master have once these changes are implemented? And how does it then link into the Minister's wider Enabling Access to Justice Reform Programme delivery plan, which was announced in December 24 and which is due to be published for consultation? So then we have Clause 29, which covers the automatic review of certain criminal records certificates. So this section of the bill updates existing legislation to comply with a 2019 Supreme Court judgment on the disclosure of non-court disposals for under 18s. So it clarifies in legislation that all spent convictions or other disposals of a person under 18 can be automatically considered by the independent reviewer prior to the issue of a criminal record certificate. So Access NI has already been referring all youth non-court disposals to the independent reviewer since March 2020. So under this process, the independent reviewer reviewed 165 disclosures with youth non-court disposals in 2023-24, removing the disposals in 159 of the cases. And the Department has also highlighted that it does not envisage any additional costs as a result of this provision. So the specific clause was not subject to consultation given that it stems from a Supreme Court judgment, but some stakeholders working in the youth sector have previously called for the full implementation of Recommendation 21 of the Youth Justice Review around young offenders being able to apply for a clean slate at age 18. However, the Department takes the view that a blanket policy of not disclosing any other disposals occurring when a person was aged under 18 in any circumstances could potentially create safeguarding risks for vulnerable groups. Finally, we have Clause 30, which covers court security. So this will amend existing legislation to provide the Department of Justice with regulation-making powers to add to the list of relevant buildings. So this will extend the use of court security officers to areas of business that are not covered by existing legislation. So they have been developed based on security recommendations and in consultation with the Northern Ireland Courts and Tribunals Service. And the Department has previously indicated to the Research and Information Service in correspondence that it does not foresee any additional costs arising from these provisions as they aim to better support the security arrangements that are already in place. So, in summing up, I've covered quite a lot of technical information in this presentation. I'm very happy to try and answer any questions, or if there's anything else you'd like me to research about this part of the bill, then just let me know. Thank you.
Thanks very much, Judith, and it was useful to get that recap, particularly in advance of our hearings that we're going to have over the coming weeks, kind of covering some of these areas. So I'm going to throw it open to members for any questions. Yes, go on ahead, Con.
Just to say thank you, Judith, that was genuinely really, really helpful and helped clarify a lot of things for me. Would we be able to have access to those slides?
Yeah, absolutely. Yeah.
I know they're based on the pack you've given us.
Yeah, we can get them emailed.
Can we get them? Yeah. Just worried I'd missed something there, but if we could get them, they'd be really helpful, I think, just for our own knowledge just going forward. Thank you.
Yeah, absolutely.
Anybody else have? I suppose just for myself, it's probably on the clause 25. I know you say, you know, it can be a positive, but I noted, I think, within it that there was no consultation done. So it was just, I suppose, if there's a way that we can seek the department's view just on what engagement, if any, there has been with the profession, just in terms of the proposed change. I know we're going to pick it up, obviously, when we meet the Bar and the Law Society and stuff as well. And then just the same, it was probably looking at the clause 27. There was a consultation back in 2022, I think it was, and the Law Society, though, had raised concerns around unintended consequences. So again, just to get clarity on the back of those consultation responses, you know, have they looked at them and what have they determined? Obviously, they're moving ahead, but just kind of the department, how they would mitigate against any of the concerns that have been raised. And then Ciara, sorry.
Just for further one, and I know that previously the department had been in, particularly in relation to clause 28, where it was early days in relation to restricting the role of the taxi master and what would be the changes or proposed changes, and I know they were doing research. It would be useful even if we could get the department and to update us and what work has been done on ensuring that it's not going to adversely impact people's access to justice, and what new system, if any, that they currently have developed to ensure enumeration will reflect and recognise the time and skill provided by the legal profession, and then how it will be monitored and reviewed. So it would be really useful to get an update on that.
Any other members? Anybody online? No. Judith, thanks very much. Obviously your papers prompted more queries and questions to the department, which is good. So again, we just appreciate your time and the paper, and we'll look forward to getting the slides as well. So thank you.
Perfect. Thanks for having me.
Thanks, Judith. Okay, members, we're going to move on to item 5, which is the Justice Bill and the Children's Panel. And I'll refer members to pages 36 to 46 of your meeting pack. And again, just to advise you that we'll have representatives from Barnardo's NI and also the British Association of Social Workers who will attend the meeting. And I'll now welcome Tressa Canavan and Orla McGibbon. Tress is Senior Policy and Public Affairs Lead at Barnardo's, and Orla is the Chair of the British Association of Social Workers UK Independence Committee. And again, just very warm welcome to the committee. Thanks very much. Again, I'm going to allow each of Tressa maybe first, if that's okay. Orla?
Oh, yes, we've got a plan.
We're flexible. Just to introduce Orla first, give an overview, and we'll maybe take questions or comments or queries to yourself, and then over to yourself, Tressa. So thanks very much, Orla. Yep.
Thank you, everyone. Good afternoon, Chair. Thank you for the opportunity to present to committee today concerning the Justice Bill. I will be representing the views of BASWA Northern Ireland and will share from my experience as a social worker in the youth justice system. BASWA Northern Ireland is part of the British Association of Social Workers, the largest professional body for social workers in the UK. It has 22,000 members employed in frontline, management, academic and research positions in all care settings, including probation and youth justice. I'm an independent social worker, but I was the former chair of BASWA Northern Ireland, and I'm now the current chair of the BASWA UK Independence Committee. I've been a social worker for almost 30 years, and I've worked as a probation officer, youth justice coordinator, assistant director and director of policy for the Youth Justice Agency. I've worked internationally with extensive experience in New Zealand, the Middle East and Eastern Europe, where I've practiced and provided training for criminal justice professionals. Most notably, from 2022 to 2024, I provided training for social work professionals, police and prosecutors in the implementation of promulgating the restorative law for children and their protection from maltreatment in the Kingdom of Bahrain. As committee members are aware, the Justice Bill is large in scope and detailed in nature. In line with the written evidence submitted to committee by BASWA Northern Ireland, I plan to speak about the provisions of the bill in relation to the retention of biometric data for under 18s and bail and custody arrangements also for under 18s. I'm also keen to outline why BASWA Northern Ireland supports raising the minimum age of criminal responsibility from 10 to 14. I aim to keep this opening statement short and look forward to your questions on these issues. Starting off with biometric testing, BASWA Northern Ireland welcomes the Justice Bill's focus on the retention of biometric data. However, there remains some way to go. The Association is particularly concerned that in the case of young people aged under 18, data can be retained for 5 years following the commission of a first minor offence, with a retention period of 25 years following a second offence. It is vital consideration is given to what constitutes non-serious stroke minor offence. There is a danger, for example, that children living in residential care settings who cause damage within residential homes receive convictions and a criminal record as a result. This is an outcome which is unlikely to be replicated where a child living within their family causes damage to a family home. Often children in the care system have experienced adverse childhood experiences, disadvantage and trauma. Offences of damage to property or assault in these settings is often born out of trauma, and retaining biometrics will see many of these children into adulthood feeling labelled by the very fact that the state, which has been unable to protect them, now views them as a future offender. Moving on to the provisions for bail and custody for under 18s, BASWA Northern Ireland welcomes the focus of the provisions, especially given the bill would ensure that following sentencing, young people under the age of 18 could only be held in the Juvenile Justice Centre. However, there remain factors to consider concerning the arrangements that will determine when a child is to be moved to a young offender centre following their 18th birthday, and there is a need for allowances in these cases where the young person is due for release within a short period after turning 18. There is significant potential for disruption associated with such a move, particularly where positive work has been completed within the Juvenile Justice Centre in preparation for release. It is also essential that the new custody and supervision orders ensure all necessary opportunities are afforded for practitioners to work with the child, their family and community to support them and avoid a return to custody. This is needed to address the situation referred to often within our profession as revolving door syndrome, where shockingly young people return to custody, in some cases to access care, with offences deliberately committed to achieve a return to a place of safety. BASWA Northern Ireland is concerned that the bill does not go far enough to legislate for alternative bail accommodation for young people under the age of 18, and we believe that it is vital that early intervention approaches inform the support provided to children and young people on bail, including provision of bail fostering beds within safe facilities. In many cases, children and young people who offend have social needs that have not been fulfilled, leading to their involvement with the criminal justice system. Finally, I want to comment on the minimum age of criminal responsibility. BASWA Northern Ireland supports raising the minimum age of criminal responsibility from 10 to 14 years in line with the recommendations of the United Nations Committee on the Rights of the Child. I mentioned at the beginning of my statement the legislation introduced in the Kingdom of Bahrain, which has raised the criminal age of responsibility to 15. This is a huge departure for the country and a significant step forward in protecting the rights of the children. BASWA Northern Ireland recognises that raising the minimum age of criminal responsibility is not addressed by the Justice Bill, but would support an increase to 14 years old via an amendment to the legislation. Thank you.
Thanks very much, Orla. I know I said I was going to take questions,
Yeah.
but I'll hold it at the end.
Sure, I
because
think that's, yeah.
it'll be pretty similar issues, and
Yeah.
then with the questions, you can decide between you who can respond. So, Tress, over to yourself then from a Barnardo's perspective. Thank you.
And thanks for the committee for having us here today. My name is Tressa, and as Deirdre said, I'm Senior Policy and Public Affairs Lead for Barnardo's Northern Ireland. We're the largest children's charity in Northern Ireland, and in the last year we worked with approximately 18,000 children, young people and families in about 40 different services right across Northern Ireland. And the range of our services go from providing family support and early intervention to working directly with children and families who've experienced adversity and need our support. And the evidence that we submitted both in writing and that I'll share here today has been informed by this work. We welcome this Justice Bill and the committee's scrutiny of it. This bill presents an important opportunity to amend Northern Ireland's legislation to provide further protections for children, and I'm going to speak today specifically about additional amendments that I'd like to see, that Barnardo's Northern Ireland would like to see in this bill. We would strongly encourage the committee to consider amendments to the bill in relation to equal protection and the minimum age of criminal responsibility. An equal protection amendment, sometimes referred to as the smacking ban, would provide children with the same protection from assault as adults. Currently, in Northern Ireland, a parent or someone caring for or in charge of a child has the defence in the law for using physical punishment against that child. That means that children are afforded less protection from assault than adults, where no defence exists. In Scotland, Wales and the Republic of Ireland, legislative steps have been taken to ensure children have the same protection from assault as adults, and MPs in Westminster are currently considering amendments to the Children's Wellbeing and Schools Bill, which would provide children in England with this protection. It is vital that children in Northern Ireland are afforded the same protection as their peers elsewhere in the UK and Ireland, and this bill provides the opportunity for our Assembly to provide that legislative protection for our children. The second amendment that we are recommending is raising the minimum age of criminal responsibility in Northern Ireland. Currently, the age of criminal responsibility, as Orla said, is 10 years old. This is one of the lowest in Europe. We have been waiting for this change in Northern Ireland for a long time. In fact, over a decade ago, a review of the youth justice system in Northern Ireland highlighted the need for fundamental change in many areas of the youth justice system, including the importance of raising the age of criminal responsibility. The impact on children, families and communities on criminalising children from such a young age can be lifelong and have ripple effects beyond any incident itself. Alongside raising the minimum age of criminal responsibility, Barnardo's Northern Ireland recommends that we also examine the support that we provide to children that come into contact with the youth justice system and how we need to rethink and reshape our approach. We welcome the opportunity to discuss these amendments in more detail with the committee and are happy to answer any questions that you might have.
Thanks very much for that. And just to say, this part of the session is being recorded on Hansard as well, so there's an official record. Anybody indicate? Kira, you're looking in, yeah.
Thank you very much for your presentations, and obviously I share the concerns about the need for greater focus on the well-being and rehabilitation rather than the criminalisation of our young people. Can you provide any further detail, maybe just from your experience, on the types of programmes you think could positively impact children in this situation? And is there any examples from other jurisdictions that you feel we should consider or be considered here?
Is that around the minimum age of criminal responsibility or the issues?
Working with children.
Working with children around the rehabilitation?
Yes. I referred to Bahrain, and what we did was we took a lot of the really good programmes that we have here and have brought them out there. What I do refer to in my briefing paper to yourselves is I have raised just a query about the opportunity that a child has a circle of support. So it's not just about the programmes that children are being asked to complete and often might complete, but it's whether any change has come from that. And what I'm suggesting is that after those, that every child should have a circle of support, which is a group of people who hold them accountable for their behaviour, but the child is very much at the centre of that. Because as we can see, when children perhaps finish a period of time with the Youth Justice Agency, that doesn't necessarily mean that they're ready to go back out into the world again, but we don't want to put extra time on their sentencing, but it might be more to support them going forward, that there's a voluntary circle of support that comes from the voluntary agencies. So for me, it's, giving sentences and placing children in custody, yes, obviously addresses some of the problem, but these children need more support because we can see that they continue to offend, or what I've said about deliberately committing offences to get back into custody again, this revolving door syndrome. So yes, we have the programmes, it's what we follow up with afterwards. So I think our programmes are good, and they're properly geared to address these issues, and they go across all scope in terms of children's learning needs, etc. All of that is looked at, communication difficulties, all of those things, but it's the afterwards, because we can take children and work with them, but we can't necessarily always change their home circumstances or where they go back to.
And if I could just add further on to that, I suppose one of the key issues is we take as much of this out of the justice system as possible. Delivery in the community violence sector is really important, and that is even more so when we talk about early intervention and prevention. So we do need to address and have those situations where a child has already gone into the justice system, but we would really love to prevent children going into the justice system in the first place. And picking up on that point around the educational needs, I mean, there's information from the department that shows that 69% of prisoners left school aged between 14 and 16, and 45% have no qualifications. So we can really see that link with education, and getting in early and making sure that children are getting the right education is so important. And part of that is about language development. So a piece of work that we do in Barnardo's is Help Kids Talk, and that works in communities to help kids have the basic language skills from a very early age, and we know that that'll help then their experience and engagement with education, again linking it all back in so that we don't have the pressures on the justice system in the first place. So we need to make sure that when we're talking about taking pressure off the justice system, we're looking at both sides of that, both how we can help rehabilitation on the one side, but then even preventing going into the youth justice system in the first place.
No, thank you very much, and I think it's critically important someone that worked out in the community with the likes of yourselves and the range of organisations do work. It is very much, we do have vulnerable young people, and through no fault of their own, but through a range of different circumstances that have ended up in the criminal justice system. Now we have had some innovative practice with a range of community organisations working with the PSNI, etc., where everyone has a fuller picture of what the current circumstances is and the issue and weighing that up and stuff like that, and that's what needs done, because we don't want to be criminalising our young people. So no, I want to thank you for emphasising that fact of that early intervention work as well is critically important. And I suppose it's just that the 5 years with regards to one offence.
Yes.
What's your thoughts on that? And then obviously second offence to 25. What's our thoughts?
And I know that I referred to children in care particularly on that, but I also thought about children make mistakes, and it might be a one-off offence, and families circle round and support, and we never see children again, but we're holding their biometric data. So to me, I actually don't sit comfortably with that. It could be my child. We don't know. For children in the justice system or in care homes, who we are trying to motivate and inspire to find a better life. They're already downtrodden in how they feel about themselves, and then to know that there's data on them, that they're labelled an offender. And we talked earlier, it was mentioned earlier about children seeking a clean slate as well at 18. Yet this could likely go beyond in terms of holding their data. What are we saying about that? So I don't know what the answer. I was actually shocked probably to read that when I saw that, because I really welcome that we're moving forward in terms of what we're doing with biometric data. But I think we've got some way to go in relation to what we maintain on children who may have committed a really minor offence and what is a minor offence. Yeah.
Oh, thank you, Jordan.
Yeah, and I know as part of the call for evidence, obviously we'll be looking at ways of engaging children and young people and boy picking others in terms of children and young people in care. So hopefully over the next couple of months, and you may, in terms of any further written submissions, we'll look at those in detail as well. And obviously we're doing a specific piece of work at the committee because some of these changes are because of European human rights judgments in terms of the court. And we just want to make sure that they're compliant. So we've been doing scoping in terms of compatibility with rights, and I suppose that issue of what's proportionate and what's not. So we'll be continuing to do that. So any further information you want to provide, keen to have it
Yeah.
in. Connie, you're next.
Thank you so much, Tressa and Orla, for coming in. I really appreciate your contribution. Something I did want to ask about, Orla, you'd mentioned that raising the minimum age of criminal responsibility to 14 is in line with UN Committee on the Rights of the Child. And I don't want to pit you against each other here, but Tressa, you had said 16. Could you maybe explain a bit of the rationale for that? And particularly just when you're asking the committee to bring an amendment with two different ages in front of us, it would just be good to have kind of the information that both of you had the rationale behind the asks there.
I suppose the first thing to say is we're definitely not pitted against each other.
No, yeah.
We both completely agree that it needs to be raised and that 10 is much too low. And the UN committee recommended that it should be raised to at least 14, but then they did say that actually they commend state parties that have a higher minimum age, for example 15 or 16 years of age. So the position that Barnardo's takes is that we should strive for the best for our children and young people in Northern Ireland, and so that's why we recommend 16. If we got to 14, we wouldn't be heartbroken. We would be able to still advocate for change to 16. So we're definitely not going to get into a to and fro over the exact number, but if we can raise the minimum age of criminal responsibility, it's key. And I mean, as the UN says, it needs to be at least 14, but if we can do better, why not?
Yeah. I think thanks for that. I think that's really helpful. It is something I think definitely needs age raised, and the age of 10 does seem very, very low, and it's something that I think myself 14 or 16, so I think more information on that is useful. So that's the only question I have, but thank you very much.
I'd be happy to provide further information
brilliant.
on that throughout the committee's consideration
Great,
of the bill.
No,
Thank you.
it's been raised. I mean, obviously we'll have the bill in front of us. It's not in it. The bill has to be approved by the executive in order to be tabled. So this issue is likely to come up again. And I know when I queried it just with officials in the department, this will be the bill that you would do it in. So at some point it's going to come, and obviously there will be different views.
Yes.
So it's good just to get an indication of what you're saying there. We're going to Gemma, who's online. It was a wee second, Gemma. We're just trying to get the technical stuff sorted to hear you.
Great, thank you. Thank you both, Tressa and Orla, for your presentations and for your written submissions. That's really useful and really interesting. My questions are for Orla. Orla, do you feel there needs to be a clear set of criteria developed by the department for when an 18-year-old is due to be moved from a juvenile justice centre? And what do you think needs to be considered and included in that?
Yeah. So a few years, Gemma, ago, I think it was probably around 2014, an arrangement was made between the Youth Justice Agency and the YOC in relation to 17-year-olds at that point. So there was an arrangement about when children could stay in the Juvenile Justice Centre, or when, because then they automatically should have been moved over to the Young Offender Centre. And the arrangement really there was that there was some flexibility around, if you were 18 and or 17 and a few months at that time, why would you disrupt the really good work and the support that you have developed with this young person in the Juvenile Justice Centre, who will get support on the way out when they leave, to make them go to the Young Offender Centre, where you're exposed to a whole different range of people and offending and all of those things, where they're somewhat protected in the Juvenile Justice Centre. So that would be, I think it's to look at, does it have to be on the 18th birthday, or is there some flexibility that both centres can come to an arrangement, and based on perhaps the child, their behaviour, their maturity, how well they are progressing in terms of their sentence, whether you would want to move them to the Young Offender Centre. So, yeah.
Yeah, so more like a case-by-case basis?
Yes,
sort of?
possibly, yeah. I think the numbers will be quite low anyway for that, but I do think that it needs to be a case-by-case consideration.
Okay. And my other question, you'd kind of briefly touched on this in your presentation there, but you said that the current bill doesn't go far enough to legislate for alternative bail accommodation for
Right.
young people.
Yes.
Could you outline what type of alternatives you envisage here?
So, the Southern Health and Social Care Trust offer bail fostering placements, but it doesn't go across any of the other trusts as far as I'm aware at this time. So that is preventing a child then going to the Juvenile Justice Centre, either on PACE or however that is. They go to a bail fosterer, who I think you're in a home environment, but you're away from family, and if the issue is with family or there's been offence against the family, it's keeping everyone safe and providing an opportunity for a situation to calm down. So if an offence has been committed and you go to court and you're given bail the next day, what I'm thinking is that rather than being bailed back to an institution, you either go back to this fostering placement, if and when available, or some sort of organisation that could set up in order to be able to house those children, with a view to building family relations again. And so, because often children as well, if parents refuse bail or refuse to take the child home, it's because they're so tired of everything that's been going on and they just need a break. But within a few days, that could be with the right support. So it's not just even about providing the placement, it's about providing the supports that we don't see this child appearing again. And again, way back, I know there were moves by the then Health and Social Care Board to provide beds within some of their placements for young people that were specifically for bail children. But I understand, I went off to New Zealand and places for a while, so I didn't know what was going on. But I understand from trying to catch up that didn't materialise. So there have been thoughts, and I know that out there people are in support of that, but it hasn't progressed.
Okay, thank you. That's actually really interesting. Something that you'd imagine wouldn't be huge to implement, but it would definitely make changes. But no, thank you very much for that, Orla, and thank you, Tressa, as well.
Thank you.
Morris?
Thank you, Chair. Thank you very much for your presentation. It's already been alluded to about raising the age of responsibility to 16. Maybe you could split the difference and settle on 15. But do you think raising the age of criminal responsibility would have an impact on the justice system caseload? Have a tooth miss, I'm sorry. And youth services? And do you think the community and voluntary sector would have a role to play in rehabilitating young people?
Yeah. So what we know already is that children are referred to voluntary agencies from the age of 10, potentially to try and implement that early intervention plan. So yes, children are already receiving that service from the age of 10 or maybe lower. I suppose our family support hubs and all of that are already possibly looking at children who are coming to the police attention, perhaps, but they're not being criminally responsible or made criminally responsible at that stage. So if we move it up, I think it allows an opportunity for the youth justice specialists to focus on the children that we still haven't been able to impact on from an early intervention point of view. But it would allow them to be less stretched in the services that they're providing at early intervention stage, but be able to really hone in. And I talked about circles of support and all those things that could be provided. So yes, it might change it around, but then juvenile justice are working with the more higher end that early intervention just hasn't been able to have an impact on. For all the many reasons, which will be family and will be community and will be all those things, but for youth justice to come in with that more specialist knowledge and interventions and programmes, I think 14 is the age. When I was working in juvenile or in youth justice, it was typically children at the age of 14 where we started to have concerns about in terms of continual reoffending or so increase in frequency, but also in terms of the type of offences that they were then going on to commit. So I think the youth justice specialists are best placed for that.
And I think,
if you don't mind, a lot of people fall into the trap of reoffending. Do you think there's enough done through social services and housing even employment opportunities don't seem to be there for people because they've been stigmatised by having a period of trouble in their life early on. Do you feel that?
Do you want me to take this?
I don't mind.
If you want to go, I can follow up.
So yes, I mean, often the children that we are working with have been known to all of those services before they've come before Youth Justice. Okay, so they've been displaying concerns in education. They will be known to the trust perhaps on a voluntary basis, but then possibly because their family are involved with the trust. And sometimes it is my sense that children, once they start to criminalise themselves or become criminal, it's often thought then it's easier just to, the children then are put into the criminal justice system and we work with them, as opposed to it should be a joint working. Now we do continue to work with social workers with children who are known or possibly on child protection registers, etc. But there's a greater emphasis and a greater priority on the criminal aspect of it as opposed to the social aspect. And you know, when we assess children, it's all in the mix. You know, what is causing you to do what you do? And we're looking to background, we're looking to family, we're looking to peers, we're looking to communities. You know, where's the failure been? Even as you say with education, these children, as Trasa referred to earlier on, often don't actually complete their education journey, or attempts to engage them or put them into smaller settings, etc., for some reason don't work. And that would be a concern for youth justice as well, especially if children are out of school, because then there's greater opportunities then to offend. Yeah.
And I suppose, you know, all of our systems are extremely stretched, and we know that there's a huge shortage of, for example, social workers in the trusts, and it's about making sure that whatever intervention we're doing, we're getting in early before problems escalate. So that's why the diversion from youth justice and actually doing that community work is so valuable, because not only are we preventing, you know, the harm that's caused through offending behaviour, but actually we're reducing that burden on our systems. And it's really important to remember as well that often where we have children that are displaying offending behaviour or engaging in those activities, it is because of the things that Orla mentioned at the start, which is those adverse childhood experiences, the things that have gone on in the family home, whether that is struggles with money and poverty, or whether that's parental substance misuse or domestic or sexual abuse in the home. So we're not looking at a child who's, you know, everything is going happily and then one day they act out. We're looking at a much broader picture and being able to understand that and get in and do work with communities. You know, there's fantastic work going on in communities about rallying around a child, rallying around a family and a whole community that is so effective at making sure that the community is there working alongside those families and those children.
Jared, just a wee
Yes,
comment.
no, look away.
I've known people when I've been growing up, they've been wee rascals, I would call them. Antisocial behaviour and low-scale criminality. Once they reach a certain age, they grow out of that and become model citizens, actually, most of them. And you know what the main driver is? Employment.
Employment.
Yeah. So
I wouldn't, yeah.
And this is where that link with education can really often come in, because if you have children who haven't been able to stay in the education system because, say, for example, they were criminalised and then brought in and then taken out of their education because they're in youth justice, and that's really disruptive, and they go back in and they've got this label, it can be really challenging to be able to then proceed into employment and be able to build a life for yourself. And it is what, you know, Orla was saying at the start of, again, around that idea that this is something that follows you your whole life, whereas actually if what we're saying is, look, we understand, you know, you're a bit of a rascal, but let's sort this out, keep you in education, keep you in the community, and make sure that we can support you so that whenever you get to that age where you kind of grow out of it and you can be able to get employment and lead life only. That, I mean, that is what our kids want.
And so many of them will tell us that I wouldn't get that job because of what I did in the past, or, you know, so they've got a fear around that. And it's back as well to those children who are care children, who already have all of that, lack of confidence, lack of opportunities. And then we've got a criminal record as well. So, yeah, it's very difficult to navigate. Yeah.
Thank you very much. Thank you, Chair.
No, thank you. And it's really interesting conversation, because just as you're talking, I mean, it's the fragmented nature of our systems, as well as them being siloed.
Yeah.
As you say, you know, the provisions may be in one trust, but they're not across the trusts. You might have a good community structure and response in one area, but maybe not in another area. And obviously we're dealing with complex family makeups and, you know, poverty and all of those layers that kind of sit on top of this.
That's probably why it's important. The Jones Review
Yeah.
has tried to bring all that
Yeah.
together and less of this silo approach as well, which we in BAS
It's critical,
support.
particularly
Yeah.
in terms of identification of those early indicators, as you say, around speech and language.
Yes.
You know, and we know even the impact of COVID, for example, in terms of that, you know, the kind of COVID baby era and speech and language delays that are appearing now. You know, so there's indicators at a very young age, nearly like trying to develop school places. You know where you are when the kids are born, and it's just, but if it's a fragmented system that's siloed, then they just fall through the net, and that's the danger in it, I suppose, as well.
And we know as well that 60% of young people who go, 60% of offenders have a speech, language and communication difficulty. And in the Youth Justice Agency in 2014, we undertook our own study of that, and that led to speech and language therapists. And we found that 58% of those young people who we looked at had all been referred, like you said, Deirdre, way back when they were children, but perhaps didn't get to the services for all the reasons that we can think of. And I know it's changed a lot with speech and language therapists now in school and greater opportunities. But yes, it's quite significant that 58% of young people in 2014 here in Northern Ireland who were in juvenile justice had speech, language and communication difficulties.
Huge flag, isn't it? Indicator, definitely.
Yeah.
I have Duke, who's going to be online. It's going to,
Thank you, Chair. And Orla and Trasa, thank you very much indeed. I mean, it's a really interesting and very complicated subject. I mean, particularly speech and language therapies. I led a debate in the chamber last year in regards to that and our lack of therapists. So it's, I mean, it's incredibly important. But just a couple of things I'm looking at a bit of clarification on if I can, and most of it's been covered by good questioning by the committee already. But Orla, you talk about stigmatization due to biometrics being retained.
Yes.
I'm trying to understand that. I absolutely get when somebody has to give biometrics, you know, the fingerprints or mouth swab or pictures or whatever. I get that, and I can feel how they can feel under pressure with the justice system. But do they really continue to think about it once it's done over 5 years, or is this just something that slips into the background? So I can't see how that continues to stigmatize them over years, as opposed to just the fact of just having it taken in the first place. Could you just sort of give us where that line of thought comes from?
Yeah, I suppose it's back to that whole labelling of young people, Doug, and this is one other thing. You know, we're holding your biometrics because, well, why are we holding your biometrics? Is it because we think, you know, you'll come to police attention again? And yes, no, it may not be at the forefront of their minds, but young people in police stations, all the anxieties that go alongside all of that, for me, it is still about, we have concerns about you, or we were expecting you almost because we've already got your biometrics. So yes, I hear what you're saying, but I still think there's a labelling aspect to all of that as well. And I suppose, and that's not just about young people in care. I mean, I've said myself today, it could be my child who has committed or made one mistake, which I am not happy about, or there's, something has happened, but I would like them to, move on with their lives and not have that label attached to them.
And I get that all.
Yeah.
And look, I'm not disagreeing with
No.
you. It's just, I'm trying to understand it. As somebody who left school at 16 and a half myself with no educational qualifications, and found myself on the wrong side of the law for something very, very minor,
Yeah.
and would have had my biometrics taken. I didn't go through the rest of my youth, all of my life, thinking, "Oh my goodness, they're waiting for me to turn up at the door again." So I kind of just, I suppose, I'm getting what you're saying, and I'm just wondering, is that something for us to worry about, as opposed to that's something that the child is worried about, if you know what I mean? But I get your point, and you make it very well.
Yeah.
The other one, I think, Trasa, you answered. I mean, Connie was going to raise something that I raised it what I was going to raise, and I think you answered it really well about the age of criminal responsibility that's 16 or 14 or maybe 15, or when you turn a teenager at the age of 13. I suppose that's an argument that's going to rumble over this next number of months. So I think that's a good one. But the last question I was going to ask, and it's just your thoughts on this. You make a really good point about transferring from youth facilities to an adult facilities. Ola, and saying, look, you come to 18. Why does 18 have to be a hard stop? Why can't it be, look, he's in a program, let's make it 18 and a half.
Yeah.
But will that come up against the issue of somebody who is committed to prison or custody who's 18 plus 1 day, and they will automatically go to an adult prison?
Well, that's-
would there be a conflict there that you can see, or is there something we would have to definitely put in place to?
I think it would have to be, there would have to be arrangements for that. I don't know. As I referred to before, I recall that it happened when the 17-year-old, so there was an internal arrangement between the organisations. So when I read that it was to be 18, I thought that's really good, but we could come up against the same things. Now, they may have that, but I thought it was important to raise it if there was a hard and fast rule. You go at 18 on your 18th birthday or that day at some point. That I think, we really need to expect that that's looked at, and that there isn't moves just because the legislation says you must go at 18, but there's some flexibility or clause within that, or perhaps arrangements between organisations. So it might be down to that.
And I think it's a fair point. I always try to look at this as well, Ola, from the side of the victim as well, and the victim looking at this as well. It's really important that we don't forget about the victim when we discuss this. And look, some victims will be saying, look, they may have been 17 and a half when they committed the crime, but you know what? This is the punishment that we would expect. But look, thank you very much. I think it's been a really good session. Thank you.
Doug, if I could just add
Yes, go on
just
ahead.
a little bit on that. I think you're absolutely spot on to raise the experience of victims as well. It's crucial because they're absolutely as much a part of the story as anyone else that we've talked about today. And I think whenever we're having this conversation about rehabilitation and young people in the justice system, what we're also really hoping for is that there are less victims / no more victims, and that we can actually work with a child and a young person so that they are able to step away from that kind of activity and they don't engage with the youth justice system, so that there are no future victims. And that's really the aim of all of this, because the aim of the justice system isn't just punishment, isn't just about condemning people for what they have done. It's actually about trying to make it so that we don't have as many victims and as much heartache as we do. So I think you're absolutely right to point that out, and to keep in mind that we're also thinking about those future potential victims that we want to prevent ever that happening to.
Could I just say, Doug, as well, I know, Ciara, you asked a question earlier, but all youth justice work focuses on victims. So there's victim is very much at the heart. You'll know that they run restorative conferences and that victims will come to those meetings or not, or put information forward, and they work to repair the harm, etc. But even in the Juvenile Justice Centre, that victim focus still remains. You are accountable for who you've harmed, and that's not just the direct victim, that's your community, that's your family. There are multiple victims in all of that, not to take away from the main or the person who has been deliberately harmed, but there are wider victims as well.
Good answer from you both. Thank you. Thank you, Chair.
Thanks very much for that. Stephen,
Yes, thank you. Thanks. A lot of ground has been covered, and a number of the points I was going to mention, but just similar, I was just keen to get that clarity, but it's already been covered between, I suppose, 114 and 116. And then I'm just interested to know, obviously Scotland's 12 and the Republic, I understand, is still 12. I suppose I'd just be keen to hear from you how you think that is working in those two jurisdictions and what impact that has had, going up from 7 and 10.
Yeah.
So I suppose in Scotland, what their plan was a view to increasing the age in increments. So they went to 12 with a view to increasing further. And I suppose what they found is they're kind of a little bit stuck, and that they haven't been able to take the following steps to be able to increase the age. So whenever we've spoken to colleagues in Scotland, what they said is doing this kind of step-by-step approach isn't working, and that actually what you need to do is, in line with the UN recommendations, 14 at the very minimum, but really 15 or 16 for best practice. So that's what I would say there. I can see why we look to those other jurisdictions, and it is important to learn the lessons of what's happened there and what hasn't worked.
Mm-hmm. And is the hard evidence there in terms of those other European countries? Portugal 16, Luxembourg 18, Sweden 15, Germany 14. And, are you 100% convinced that ultimately it will have the outcomes that we all want to aspire to? Less crime, less young people getting involved, in our
I don't have that information to hand, but more than happy to go away and get that to you and share it with the committee.
Yeah, that would be quite helpful, yeah.
Thank you.
Okay, thank you, folks.
Thanks, Stephen. I suppose following on from that, because you give the example of Bahrain and stuff as well, and I was going to really ask, because this will form part of the debate going forward in terms of this issue. There's no doubt about it. You've answered the kind of increment stuff, so it was really just reviews that are built in, so if you were moving in a direction of travel and the thrust of this bill does move us in that direction of travel, it just doesn't have it in at this point. Or were there caveats or anything built in, so for certain offences, then there were caveats built in to the age increasing? Or what way did it work?
No, it's raise the age to 15.
Just okay.
Which was previously 8.
Yes.
Yeah, so that's why it's such a big departure. But, I mean, when Stephen asked the question there about Europe, I don't think it's right for me to kind of compare Bahrain and their process in terms of how young people and why young people at times were placed in custody, and it was for things that we wouldn't do. Yeah. So that this is why it's such a huge departure, and that they went to 15. But
exactly.
yeah.
Okay, no, that answers. Thanks very much. There's nobody else indicated, so again, I just want to take the opportunity to thank you for your time and the submissions, and also for coming in front of us. And as I say, we'll be looking at these in a lot more detail. We're going to be discussing our call for evidence and when that's going to go live. So just keep an eye out. And as I say, if there's any additional information that you want to provide or evidence, we're more than happy to take that in. So again, just thanks for your time.
Yeah, thank you.
So much.
Thank you. See you later.
Thank you.
Later. See you later. Oh my God, it's grim. Okay, members, we're going to move on to item 6, the Justice Bill, and this is the proposals on the call for evidence, and it's in pages 47 to 73 of your meeting pack and pages 3 to 29 of the table pack. Just to remind, committee had an issue on the call for evidence on the Justice Bill once the text of all the amendments. We had agreed that we wouldn't issue it until all the amendments were received. We know that there's still the live links that are outstanding. They're due to be with the committee tomorrow, as was presented by the officials at our last week's meeting. So just to advise you that it's good practice when seeking the written evidence on a bill, obviously to issue a media signposting notice. And anyone with an interest in the bill to submit any written evidence. A draft signposting notice is included in Appendix A at page 52 of your meeting pack, subject to receipt of the text of the amendment. It is also proposed that the notice is issued during the week commencing the 3rd of February, and that it would run for a period of 6 weeks with a closing date of the 21st of March. Now, obviously, in all of this, I know some may have wanted that longer. We obviously have the extension of the bill, but we want to make sure that we're giving ourselves enough time as well in terms of considering the bill, but also any amendments that may come from this committee and stuff as well. So we'll always have to think of that timeline at the other end, and in the context that we're due to get the sentencing bill in the autumn as well. So again, just to advise members, in addition to writing to those listed in Appendix C and Appendix D, the committee should identify which organisations it may wish to invite to give oral evidence. So if there are suggestions now, or we can hold off at another point, then we can then consider if there's somebody else that we want to get in for oral evidence, then we'll do that, or if we're satisfied. that we have their written submissions, that may suffice as well. Again, I just want to ask firstly if members are content. Do you agree that the call for evidence will run for a 6-week period from the date of the issue? Now, obviously, as I say, we're waiting on the live links coming tomorrow, so we want to wait and then issue all of that. If there's a slight delay, we may push it back slightly, but again, we want to move as quickly as possible. There are some organisations don't want to come in front of us yet until the call for evidence is issued and they can see everything in its entirety. So are members content with the 6 weeks, or I'm taking your silence as agreement?
Standard practice.
I'm content.
Yep, yeah, it is standard practice. Yeah. Okay, just to ask members if you're content to agree to the draft media signposting notice, subject to an amendment to include the closing date. So that's just on the basis of receiving the live links amendments by tomorrow. Members content? Yep. And just to ask if you're content to agree the draft letter to issue to stakeholders. Content? Yep. Ask members if you're content to issue a stakeholder letter to those listed in Appendix C and D. And again, I would advise members, if you want to add to that, just let the clerks know if there's organisations maybe that we haven't thought about. But I know that we've tried to extend that list beyond from when it was previously discussed, and particularly those who responded to previous legislation. So it's tried to be as wide as it can be. So are members content then that Appendix C and D, that we will issue the letter? Agreed. And again, just to ask you if you're content with the citizen space questionnaire in the tabled pack. So that will be the questionnaire that's issued. Is there agreed with that?
Agreed, yeah.
Okay, and just again to ask members to identify which of the stakeholders they may wish to proceed to take oral evidence from. Again, I'm also going to ask the clerk to advise of any stakeholders that the committee may wish to consider in giving oral evidence to the bill.
Thanks, Deputy Chair.
Yeah.
I think, as the Chair mentioned, some organisations or individuals might not want to come until they've seen the call for evidence, but I think at this point there are a few that the committee might be able to hear from in the meantime. There are some have already been scheduled, particularly in the biometrics, but I think that there are, for example, the PSNI might be able to come at the moment, Probation Board, the Public Prosecution Service, SIGINI, the Equality Commission are ones that maybe could go ahead at this point in time. And the Chair mentioned, during the research briefing, that it would be useful to hear from the taxing master. I'm not sure who or how, but that's something that we can look into as well for you. So would members be content if we start making arrangements to hear from those organisations at this point in time, and then there will be more as the weeks go on that members themselves may wish to suggest, and as I said, the call for evidence as well is likely to throw up some that the committee might want to hear from. And again, we have the stakeholder list, and at any time members can bring back any of those as well for the forward work programme.
Yeah, I think we're just trying to find the balance, because I know we discussed before, to make sure that we're obviously hitting the organisations that we know that work in these areas of work at a strategic level, but we also want to have that grassroots perspective in terms of the impacts or how the legislation is felt at the other end. So it's important we just try and strike that balance where we can. Connie, yep.
Yeah, on that, that leads quite nicely in, Deirdre. We're just very conscious we had a panel there where we were talking about young people but weren't talking to them, and I know there's a lot of organisations such as NICI and the Northern Ireland Youth Forum. We've got our Youth Assembly where they have panels of young people that do work on some of the issues that might be of interest in this bill, and I think if we're reaching out especially on the issues around children and young people in the bill, could we maybe include in that we would welcome if any of their people from the young people's panel want to come forward and present to committee. That would be welcome as well.
I think, thanks, Deputy Chair. We have spoken to the officials that work with the Youth Assembly in Parliament buildings here, and they are working to get a submission from them, but they might not necessarily be representative of children maybe involved in the justice system as well. So I know that Thomas has been in touch with VOIPIC and Include Youth, And the intention is to arrange something that would maybe the children involved with those organisations would be comfortable to participate in. So it might not necessarily be formal evidence, but we will try and arrange an event through those organisations to hear from children.
That's brilliant. I think that's a really good idea, and I think it's important that their voices are heard in this. So yeah, thank you.
Yeah, no, I agree. I think we need to hear that direct experience. Ciara,
Just following up on that as well, I'm very keen that grassroots organisations, your neighbourhood renewal partnerships, have worked with collectives of a range of organisations to provide that circle of support, which is where there's a range of fantastic models of good practice. They don't have policy officers to be able to dedicate time to be going through bills, etc., but just their lived experience of work that is productive and their thoughts on the impacts that it can have on families, not only maybe the young person, the victim, but also the families, the neighbourhoods and the community. So I would love to see, and I know we did previously discuss different models of how we engage, if there was a way through the call for evidence that we could work through the likes of neighbourhood renewal partnerships, even perhaps, where I know in one of my other committees we're actually doing a long gallery event of a round table event. So we're going to the grassroots, asking them to nominate ones in their neighbourhoods and their communities up to a discussion where members here in the committee can sit in a round table and maybe in quite simple terms, unpack and have discussions on particularly the 4 key areas. I would welcome if that's something we could consider. I know it's a lot of work, but I see very much high level organisations, and I think we're missing a trick by not really getting into the heart of neighbourhoods and communities that are living it every day and feeling it every day and supporting people every day in this field.
I think I'm assuming members would be content if we looked at that, because I think even family support hubs that was mentioned, because they would be working obviously with the agencies and stuff as well, and even if the likes of NICFA or something like that, in terms of looking at the voluntary and community sector, but making sure there is that grassroots and it's not just the regional, would be important. But are members content then if the team go away and look at something and then come back to us on that in terms of children and young people?
Just to say as well, when we were talking to Include Youth and VoIPIC, they were saying that they have a network, and that's part of what they would be doing is they would be going out to the rest of the people within their network, which is community groups and local groups, and seeing what they can do. So something like that along the lines with NICFA. I think Kathy had already suggested that. So
yeah, absolutely. We will look into to arranging and facilitating an event like that. That won't be an issue at all, and members can let us know the type of, you've mentioned a few different kind of organisations and partnerships as well, so might need to come back and find out more on some of those that you want to include, or from all members. And we can certainly look at an event. Absolutely.
The neighbourhood renewal, there's a strategic group that covers all of that, but then it'll feed into all the areas of high deprivation, family support hubs, even the rural communities network. I'm thinking just even from a rural perspective, are there different dynamics at play that we need to be aware of? But then if there's any others that members feel, then just feed them into the clerk's team, then there's no problem at all. Okay, so are members content with that then?
And it might be useful rather than the long gallery even going out. Maybe an organisation could host us out in a community.
Chair, I know that NICFA hosted the Economy and Finance Committees yesterday in a joint event as well, and so there are options to go out as well.
Oh, thank you.
If you've somewhere you're eager to go to, let us know.
Do you? Yes. To go on there's fantastic facilities probably in my own area, but particularly in an area where I work, the likes of Chantal Community Centre. It's an amazing centre. I think it's one of the best across the island actually. It was quite new, but at scale and size it could very much cater for a large event as well.
We can look at some options and give them to the
committee. Members, just if you feed them in then to the team, and then we'll look at that. No problem at all.
Also for me to get to.
Okay, so we're going to move on then, if members are happy enough then.
Yep.
Just with all of that, have you everything you need? Yep.
Yes,
okay, so item 7 then is the organised crime. This is obviously a written briefing paper from the department on pages 75 to 79. So just to advise you, obviously, that the department just are given an update on proposals to update the strategic approach to tackle serious and organised crime a review of the Organised Crime Task Force, looking at structures and governance arrangements. The Department have advised that they're considering how best to take forward a more cohesive approach to the issue, to the threat, risk and harm across safer community spectrum, as well as refreshing the organised crime strategic approach. The Department are also developing a strategic approach to community safety and states that it is aware of the need to mainstream the best practice elements of the approach in tackling paramilitarism. So again, they believe that they should have a single framework, and they're seeking to have that in place by 2026-27. And again, a review of strategies and the strategic framework across the Safer Communities Directorate. And I know from time to time we'll get oral briefings from the officials in each of those as well. So again, you have the written briefing in front of you, just to ask if you're content or if anybody wishes to raise anything pertaining to the briefing.
It will come back to us.
Yeah, we'll get updates, as we're going along, I think I would agree. I mean, I'm trying to kind of look at the broad spectrum and bringing all of these things together. It makes sense.
Sure.
Yes, go on ahead, Justin.
Sure, my hand's raised function's not working there.
Go on ahead, we
Just
can hear
a
you.
thing I've raised before at committee, and that is proceeds of crime. Can you hear me okay?
Yes.
Just an item I've raised before, and that relates to the proceeds of crime in relation to organised crime, and even though of legacy nature, and where the paramilitaries have accrued huge finances through criminal activity, racketeering and intimidation and other criminal pursuits. Can we get a briefing from some of the legacy organisations to say what has been done to explore how those monies can be retrieved, or where those monies have been gone, and who has actually disposed of all of those finances from a paramilitary perspective and organised crime perspective, which they were often engaged with for the most part?
Okay, Justin, sorry, I'm just having a discussion there in terms of who, unless there's specific agencies that you want to inquire. I mean, we'll put a query into the department. There's a paper just arrived today looking at some of this, which is going to be in next week's pack. So I don't know if you want to get a view of that first, and then we can raise it in terms of that item. If there's anything additional that you're looking for more detail, then more than happy to ask the department for it.
Okay, fair enough, Chair.
Thank you, and we'll raise that next week. Sure, we'll make that a point for the chair. Okay, are members happy enough to note the briefing then on? Yeah, okay, thank you. Moving on to item 8, which is correspondence. So again, this is in pages 80 to 202 of your pack, and just I'd like to draw your attention to a number of areas of interest. So item 8.7, just to refer you to correspondence from the Finance Committee on page 119, following correspondence from the Committee of Finance. They've obviously sought views from the Department of Finance on the merit of an amendment to the Civil Service Staff Handbook, which would reflect the unique circumstances and challenges of prison and custody officers and other prison service staff. The Department's response lists a number of services and initiatives that are available, and concludes that there are no plans to create a separate annex to the handbook for prison service staff. So I'm just asking for members to note that response, or if anybody has anything to raise. Okay, noted. Okay, I refer you to item 8.8 in the correspondence from the Northern Ireland Judicial Appointments Commission on page 129 regarding a joint event with the Executive Office Committee that has been scheduled for the 25th of February. They have requested that the event is now postponed until a more suitable date in May or June, and just to ask that you're content that we reschedule. Members content? Yes. Again, in the table pack on pages 31 to 32 is from DOJ. It's a news release from the Minister outlining her commitment to engage with the legal profession in light of the Criminal Bar Association announcement that it plans to extend its withdrawal of services. Anybody, any issues? I suppose what I would like to ask here is just if we could get an update from the profession. I know there's been obviously press releases, the likes of the bar have extended their action for another month. So I would just like to get an update from them on, you know, what engagement they have had, what the key issues are. And I would be keen to see that. And obviously we have the letter from the Minister as well, outlining her steps also. Are members agreed with that, or content, sorry? Okay, thank you. And just to say, sorry, that there is correspondence in from the bar today, which was circulated to all members. The letter advised of the extension of the withdrawal of services, as I say, for another 4 weeks, taking us through February. And again, they just say that the department have failed to meaningfully address the concerns highlighted by the bar. So again, just to remind you that, you know, we did seek information on the engagement with the sector on these issues and request a clarification. So just to ask if you're content to note the department's press release, the correspondence, and obviously we're going to ask the bar and the other elements of the profession just for more information on this issue. So are members content enough? Yep. Okay, thank you. Just to remind us then, again, it was another email sent out to you all yesterday, the review of the policing board, and he advised that obviously the copy of the independent review of the policing board was emailed to members in strict confidence. The report has now been published on the website this morning. And again, just to seek your agreement to include the written report on the agenda for the committee at next week's meeting, just to allow members time to look at that. There may also be, I suppose, a response from the Minister in that period as well. So are members content then that we place that on the agenda for next week? Okay, thank you. Happy enough. And again, just to ask if you're content to note all the other items of correspondence, or if there's anything you'd like to raise. Okay, noted. Yeah. Okay, just to advise you, thank you. Item 9, the Forward Work Programme on pages 204 to 211 of the meeting pack, and the Department of Justice Forward Work Programme on page 212 of the pack. And again, just to seek your agreement to schedule the proposed items of business from the department in the work programme going forward, and to seek agreement on the Forward Work Programme subject to changes as agreed during today's meeting. Are members agreed? Yep. Okay, thank you. We'll keep it under review anyway if there's any changes or that we need to do. I'm sure we can be flexible. Again, just to advise you of a proposed visit to the Northern Ireland Courts and Tribunal Service at Lagenside House on Thursday the 20th of February. So instead of committee, there is that proposed visit that day. And again, just your information in the itinerary is in the pack on pages 213 to 216. So just to ask if you're content with the proposed itinerary. We obviously tried to do this visit before Christmas and it wasn't practical, so we'll have rearranged this, I think, a few times. So are members content? Yep. And just to indicate then at this point, or when you can, if you're able to attend that visit or not. And I suppose I want to indicate that I'm unavailable for that visit, so just to have that noted. And then other members can inform the clerks. If you don't do it now, you can do it just before that event. Okay, so thank you. So again, just to email, sorry, for those that wish to attend, they need your car registrations and stuff just to sort out parking. So if you're going to that court visit on the 20th, if you can just let the clerks know as quickly as you can, just so that they can make the necessary arrangements. Okay, we're moving on to item 10, which was chairperson's business. There's no business from the chair, the deputy chair, you'll be glad to know. Item 11, any other business that any members would like to raise? No? Okay, just then the date and time of the next meeting is next Thursday the 6th at 2 p.m. here in room 30. Thanks very much, everybody. See you later.
Committee room 30, sound.